and Hazwani as a timekeeper. We will begin the round whenever you are ready. The court is now in session. The judge for today is Mr. Shamil Fikri, and the appellant is represented by Nur Umara Izati, and the second appellant is Siti Nur Afika. The respondent is represented by Muhammad Mustafa bin Abdullah and Muhammad Arif bin Masiran. Counsel for the appellant and the respondent are each allocated 40 minutes to present their respective cases, which is inclusive of maximum of 5 minutes each for their rebuttals and surrebuttals respectively. We will now invite the first oralist to begin their submission.
Am I audible to the court, my lord?
Sorry, Mr. Shamil, your voice.
Is it okay? Yes.
Yeah.
Proceed, please.
Much obliged. Good afternoon, my lord. May it please this honorable court. My name is Nur Umaira Izati binti Ahmad Zaharuddin, appearing as the senior counsel on behalf of the plaintiff, and together with me, my learned co-counsel, Ms. Siti Nur Afika Siti Azizi. Appearing together are the learned counsels for the defendant, Mr. Muhammad Mustafa bin Abdullah and Mr. Muhammad Arif bin Masir. It is an honor for me to appear before this honorable court. My lord, I will be submitting on the first issue for 18 minutes, while my learned co-counsel will be submitting on the second issue for another 18 minutes, and we will reserve 4 minutes for rebuttal. Before I begin my submission, do my lord appreciate briefly summary facts of the case? Much obliged.
Yes.
Much obliged. The plaintiff suffers multiple sclerosis, which was considered as secondary progressive multiple sclerosis by the first respondent, who is an independent medical consultant at SMX Medical Center, through the symptom of numbness in her left and right limbs. My lord, my apologies, I could not clearly hear the question. Pardon?
Can you not go too fast, please?
Oh, sure.
Okay.
My lord, as there were no referral made to any specialist for confirmation made by the first respondent, plaintiff underwent her first medical treatment with the first respondent on October 2017. But since she moved to Sandakan, she continued to be examined by Dr. Hans in January 2019. After she underwent treatments in XYZ Hospital, the symptoms that she had turned into a bladder cancer, and the cancer left her with gastrointestinal obstruction and bleeding problems. Dr. Azrai, a pathologist from Seremban Specialist Center, said that plaintiff would have a remission chance of 40% and survive for 10 years if only there were no delay in referral made by the first respondent. Therefore, with regards to the first issue, we argue that the trial judge erred in law in finding first respondent not liable of medical negligence. To argue on the erred made, I will divide my submission into two parts. First, I will argue that there is a breach of requisite standard by the first respondent, as there is a delay of referral of the plaintiff to specialists. And secondly, I will argue that there was a chain in causation in law in damage suffered by the appellant, as she had suffered injury as a result of the first respondent's breach of duty. My lord, may I begin my submissions properly?
Counsel, before that, I have your memorial submission. Do you prefer me to read your written submission as well, or you want me to take it just from your oral submission for the time being?
For the time being, I appreciate if the sorry.
Sorry, Mr. Shamil, I think your mic problem.
My
Or
problem.
could you wear earphones or headphone if you have?
Okay, I'll try to come again.
Okay.
For the first counsel, can you clearly hear me?
Yes.
Yeah.
Thank you.
I'm giving you liberty now. Do you want me to refer to your written or memorial submission, or you prefer me to just to take it from oral submission for the time being?
I prefer any way that you comfortable with.
Right. Can you confirm that your submission is in line with your memorial submission?
Yes, my lord.
Okay. Yes.
Much obliged. So may I begin my submissions properly, my
Yes.
lord?
Yes, please.
Much obliged. My lord, in submitting on the breach of requisite standard, there are two sub-arguments that will be submitted. First, I will submit that the first respondent owned a duty of care towards the appellant on doctor-patient relationship basis. And second, the respondent breached the standard of care practice by failing to make an immediate referral and to advise the risk and possible treatment. My lord, as mentioned before, the first sub-argument is the first respondent owed duty of care towards the appellant on doctor-patient relationship basis. In the case of R. N. Bateman, the Honourable Court held that the doctor-patient relationship will arise from duty of care of a doctor to use diligence, care, knowledge, skill and caution in administering treatments to a patient. In submitting that the first respondent liable for medical negligence, we also referring to the case of Fu Fiona and Dr. Su Fuk Moon and another. The Honourable Court stated that duty of care owned by a doctor arises out of his relationship with his patient. Also, in the Court of Appeal held similarly in the case of Hassan Vedatullah and Kerajaan Malaysia, it is the practitioner's obligation to advise his patient who is capable of understanding such information of risk associated in any suggested therapy so that the patient may make an informed decision whether to proceed with the planned therapy, knowing the risk involved or decline to be subjected to such treatment.
Consent.
Yes, my
I
lord.
stop you for. You are saying that there is a doctor-patient relationship between the the appellant and the first respondent, is it?
Yes.
Could you describe that this what kind of relationship is this? Is it a fiduciary relationship, or you didn't mention at all?
My apology. Could I rephrase the question?
Okay, you are saying that there is a doctor-patient relationship, and you are citing some of the cases. Are you referring this as a just doctor-patient relationship, or you are saying that there is a fiduciary relationship?
We are addressing only the doctor-patient relation.
Doctor-patient relationship.
Yes. May I proceed, my lord? Much obliged. In the present case, as the appellant had acknowledged the first respondent is a medical practitioner when she first sought for medical treatment in 2017, the doctor-patient relationship was established. Thus, the first respondent owes a duty of care to the appellant. Pardon? Sorry?
You are saying October 2017?
Yes.
All right. So you are saying that this doctor-patient relationship established on October 2017.
Yes.
So you proceed. I need your clarification because I believe it was clear in the mood problem, or here it is our fact of the case, saying that Dr. Kevin is Amrita's regular doctor. Can you confirm that actually when does this doctor and patient relationship exist? Is it October 2017 or before that earlier?
In October 2017, my lord, when she first sought medical treatment from the first respondent.
prior knowledge between there's no any relationship existence between the parties. There's no prior knowledge.
May my lord rephrase the question again?
So you are saying that there are no prior knowledge on Amrita, sorry, Dr. Kevin, because I believe in the mood problem and the clarification already made it clear that there is a prior knowledge and there is also meetings before October 2017. Are you going to submit that those facts are materials or no?
No.
So you are only relying on the meeting on October 2017.
Yes, when she first sought medical.
Okay, please go ahead.
Much obliged. My lord, thence with submitting that the first respondent owing a duty of care towards the appellant on doctor-patient relationship basis. Next, we will submit that the first respondent breached the standard of care practice by failing to make an immediate referral and to advise the appellant of the risk and possible treatments. Referring to the case of Ahmad Takif Amzar and Kuala Terengganu Specialist Hospitals near Berhad, the High Court held that the doctor was negligent by breaching his duty of care to the plaintiff in failing to issue a referral letter to take the plaintiff to another hospital as soon as possible. The second defendant, on the other hand, had shown no urgency in subjecting the plaintiff to further examination. While in the case of Dr. Hari Krishnan and another, and Megatno and another, explaining the risk of the operation to a patient is a standard of care that needs to be exercised by every medical practitioner. The failure of the doctors to exercise usual practices of medical practitioners has put them in a breach of duty. In the
Do you have further cases to refer? I try to make it simple for you.
further cases for failing the failure of doctors.
Okay, of medical practitioner, that's your issue right now, right?
Yes.
You have other cases? Because if no, then if I'm interested to see how you apply the case. And,
All right, my lord. I will be explaining the application after this, right after this. May I proceed, much obliged?
yes, please.
In the present situation, the first respondent is the greatest extent responsible for the immediate referral to a skilled multiple sclerosis specialist that aware of the symptoms and equipped to manage multiple sclerosis. The appellant should be treated immediately, and the fact that symptoms had appeared 9 months prior was necessary to persuade respondents to make an immediate referral and to advise the respondent about the disease implications. Applying all the laws and cases, the plaintiff submits that trial judge erred in law in finding first respondent not liable of medical negligence. Therefore, the first respondent is liable for medical negligence. My lord, may I proceed to the second part of the issue? Much obliged. Having finished with the first submission, I shall now move.
Can I stop you for a while? I think I'm not done yet with the first issue. My question is that what is your expectation actually on this first appellant? Sorry, and on the appellant. Sorry, on the first respondent. What is your expectation?
We expect that the first respondent did not delay the referral, as he seems not to be equipped and experienced in handling multiple sclerosis cases.
The first respondent already gave quite an answer to appellant, which is SPMS, secondary progressive multiple sclerosis. Basically, that is an answer for the diagnosis. What I wonder, what actually do you expect more from the first respondent? Because you know, in the medical law, does the doctor have the have does the doctor can ensure that they can refer this appellant to a further treatment, because there is the question on the consent on behalf of the appellant. I mean, I go to the fact here that what else do you expect from the doctor? He already gave the answer of SPMS. Even anyone can Google SPMS. What is the risk of it? Does it require the doctor to explain? Furthermore, to foresee that there is a risk to be the existence of the bladder cancer. I mean, that's the answer already. The doctor already informed SPMS. What do you expect more?
We expect that he disclose the risk that will be suffered in future. As the court could see that we've mentioned about the bladder cancer and gastrointestinal obstruction and also bleeding problem. The first responder did not disclose the risk that the plaintiff would suffer in future if she delayed the treatment. There are treatments needed in the future to somehow lessen the pain of secondary progressive multiple sclerosis. Shall I proceed, my lord? Since we have 5 minutes left, can I request from the court to grant me a few additional minutes?
Can I do that? Sorry, the committee, can I do that? Since I interfere the submission, if possible, then I might ask for extension of time.
Much obliged, my lord. So I shall now move to the next submission concerning there was a change in causation in law in the damage suffered by the appellant, as she had suffered injury as a result of first respondent breach of duty. And the second sub-argument is the foreseeability relates to kind of injury, not its extent, by using eggshell skull rule. So in Hyde and Thames side, the Court of Appeal held that the hospital staff are not liable under negligence as they cannot foresee the damage suffered by the claimant. Different from the present case, the first respondent can foresee the damage that will be suffered by the appellant if he delays the referral of the diagnosis. As the appellant was being diagnosed with secondary progressive multiple sclerosis when she was admitted to first respondent in October 2017, he should foresee the consequences of the damage if she did not get early treatment. This is because if someone suffers from secondary progressive multiple sclerosis, there is a chance that the person will have bowel and bladder malfunction. Also, people who suffer from secondary progressive multiple sclerosis could lead them to have cancer. Yes, my lord?
Okay, I was wondering, can I take this as in your submission in this court, you are as a lawyer giving your medical opinion? Because you are saying there is a possibilities of you are giving your medical opinion. Are you sure?
My lord, we try to submit that the respondent is liable for medical negligence, but we did not try to mention that medical opinion is binding and the case is bound to the medical opinion. But in handling this kind of case, there is not many cases similar to our present case. Therefore,
Is it the similar medical condition?
because multiple sclerosis.
Causation, right?
Sorry, my apology.
Lord, which do you think more important? Is it disease, what kind of disease it is, or the issues that you are handling? But the issue of causation, right? And I believe that when it is causation, I understand that you want to say that there is a possibilities when there is uh, when there is SPMS, there is a possibility that the patient will get bladder cancer. Okay, that's your submission, right?
Yes, my lord.
That's what I'm saying. Are you submitting to the court your medical opinion? First,
Actually, it is not our medical opinion, but we rely to reliable sources that explain more about multiple.
which process you are referring to?
Um, I'm afraid to submit that we rely to secondary sources.
Secondary resources. Can you assist the court? Can you refer to the court?
Okay, so
Or you want me to disregard on this matter? Actually,
no. I would like to, I would like to explain on
yes, yes, please.
our secondary sources.
I hope the bailiff don't mind if I ask some extension of time for the first counsel.
Yes.
Okay.
Okay, so we rely on a journal written by two famous neurologists. As we know, multiple sclerosis is autoimmune disease, which relates to the neuron in our brain. Uh, the journal was entitled "Understanding Progression in Multiple Sclerosis." From that, we rely that people who suffer from secondary progressive multiple
So
sclerosis.
you are stating the medical journal here, right?
Yes, my lord.
I really appreciate your research. Just something to ponder here on this is appellate jurisdiction. I think you made it clear in your written in your memorial submission that this is an appellate jurisdiction because you know when we talk about the procedure of the appeal, um, when the facts have been finalized and what is the position of medical journal here? Is it an evidence, facts, or is it the law?
We would like to present facts.
It is a fact, right? It is a fact, right? Because I believe in the appellate jurisdiction, the facts are clear already. How could you make another reference to the to another external resource here? Unless
My apology, my lord. We are trying to address the risk and the possibility that the first responders
I can't hear you. Sorry.
we would like to address that the fact that we presented today is basically to enhance, to address the first responder should disclose the risk and the consequences of the disease to our client.
Uh, we are okay. You as a counsel here, you are a lawyer. Then you manage to make a medical opinion on the possibility SPMS. Now I'm asking you, uh, whoever Dr. Amrita, sorry, Mrs. Amrita is, she's not a doctor. Now I'm putting it like this, that even you as a lawyer can give that kind of medical opinion. Why can't Mrs. Amrita can make the same due diligence on what is SPMS is? Because the way I see it is that the doctor already give the answer on what to refer to. Just SPMS, Google straight away. In fact, you can submit to the court on what is SPMS here, right? Does it require a doctor to explain to you? Because I think the doctor have made a good job by determining that this is SPMS.
Indeed, my lord.
Okay.
However, the relationship that exists between the first respondent and the plaintiff, which is doctor-patient relationship basis, prove that the plaintiff,
Okay. Please, I'm listening.
the plaintiff had belief in the first respondent's conduct. Therefore, she trusted him to give her further explanation and treatment, and even if he can recommend her to other doctors or hospitals for treatment.
That is your suggestion, right? That is
Yes.
your suggestion. Basically, that is your positive suggestion on what he should do. The issue that you are raising here right now is that what does he fail to do? upon your explanation, did he fail to give anything else? Because I think he did his job well. He gave the answer already on SPMS. And the rest of the information is supplementary, that anyone can access it. In fact, you can give the medical opinion. You can make the research on what is the effect of SPMS now.
My apologies, my lord, I could not assist the court on this particular matter. Shall I proceed?
I think I have to disregard this issue as well. I'm sure this is your main issues, you know. Yes, you can try. You still got time, right, Mrs. Belly?
Yes.
May my lord rephrase the question one more time?
Yeah, I'm putting it like this. Basically, you are saying that the doctor has failed to give. You are saying that the doctor failed to inform the appellant what is the possibilities, what is the risk of having SPMS, right? I'm telling you this. That Mrs. Amrita or the the appellant, she did not require that from doctor, you know, because anyone can. The moment you know you have SPMS, you can do your own research. You have the responsibility to do your due diligence, because I'm relating it to our condition, our situation right now. Even you as a lawyer can give the medical opinion to the court. I mean, does it require a doctor to do that? Maybe I try to make a leading question to you. Are you saying that there is a doctor-patient relationship? Do you agree if the moment Mrs. Amrita met the first respondent, you are saying that Mrs. Amrita feel absolved, she feel relieved, no, like he doesn't care, no matter is it SPMS or what, but she absolved with her responsibility, and you are saying there's no further referral, then it's fine because the doctor didn't give any referral, is it? That's what you
Yes,
are
my
saying.
lord. Indeed, my lord. But since multiple sclerosis that we present here today, symptoms are quite regular for even for an ordinary person. Numbness, and she had the symptoms for 9 months. Therefore, multiple sclerosis is hard to diagnose. So therefore, in those period that the symptoms on and off, um, the plaintiff relied on the first respondent's further referral.
Are you done with the submission? Because I had a question. Or you
I couldn't hear you.
submission, or because I have other question to ask.
Yes, my lord.
Okay, if you are referring to the mood problem or the facts in this case, if you realize, can you give maybe your commentaries after the appellant met Dr. Hans, it was recorded that there had been some steady progressions of signs and symptoms without any relapses. You get me? Are you following?
Yes, yes, my lord.
Do you understand what does it mention there?
It is mentioned that when he met Dr. Hans, she suffered relapse. For secondary progressive multiple sclerosis itself is a relapse from multiple sclerosis.
Mm. So is it when he met Dr. Hans, there is another symptom, is it?
We
Because it says there is a steady progression. There is a uh, steady progression means there is a progression, constantly progressing. Of course, in the fact it doesn't mention that what is the new symptoms or if there is another new symptom, but instead that there is a steady progression, means it's developing. There is a possibility that, oh, that's my time or time. Okay, so because when you are discussing about the issue of causation here, you get me? You are trying to say that there's a link, right?
Yes.
Probably if on to 2019, my case, I will say that if on 2019, if Ms. Amrita met again Dr. Kevin, then Dr. Kevin will do the same as Dr. Hans. Do you agree?
Now, um, my lord, indeed, but I beg to differ. As as I explained earlier, that multiple sclerosis itself, the relapse may take few years to appear. Therefore, if the relapse did not happen when the plaintiff seek advice from first respondent, but the first respondent could foresee that the relapse will might happen in the future. Therefore, uh, that is what we try to submit, that the foreseeability that can be foreseen from the first respondent.
Thank you.
Pardon, my lord?
Very much.
May, may I am I allowed to
Sorry,
much obliged? Okay.
do you have any addition? Anything to add?
I would like to ask to request the court to give me uh, additional minutes to conclude.
Uh, 1 minute, can?
Sure. Much obliged. In the present case, the appellant suffers gastrointestinal obstruction and bleeding problem, which caused her to feel weak and lacking in energy. This condition could be seen as the extension of the appellant's damage. The extension of the damage cannot be foreseen, but the fact that Dr. Kevin, which is the first respondent, could foresee that the appellant will have the cancer means he is liable for all damage suffered. In conclusion, my lord, the plaintiff submits that there is a breach of requisite standard by the first respondent, as there is a delay of referral of the plaintiff to specialists. Thus, the first respondent also breached the standard of care practice by failing to make an immediate referral and to advise the appellant of the risk and possible treatments. My lord, is there any clarifications needed by the bench before my learned co-counsel continues submitting the next issue?
Oh, thank you, Doctor.
Much obliged. May it please the Honourable Court. My learned co-counsel will continue to submit on the remaining issues. Much obliged, and may it please the Honourable Court.
I'm sorry to interrupt. I would like to suggest to Mr. Shamil to use earphone if you have one.
Sorry.
Because I would like to suggest you to use earphones
Your phone.
because
I'll
you're
go to
because,
Can
sorry.
you give me a moment?
Okay, thank you.
Right. Wait. Can you hear me?
Yes,
Is it much better?
much better. And I think all the participants have to mute when you're speaking because your voice like I think all sorry
Okay, come again, please.
I think all have to mute their mic because when you speak your voice a bit like
Does it sound robotic or what?
no tak dengar langsung. It's like
I see.
uh,
It's unfortunate because I hope that won't prejudice the session. Now, confirm it's clear. So since our first counsel is the first counsel, I will give some consideration on that on the party.
Sorry, your voice a bit slow.
Can you hear me now?
Ah, yes.
Wait, I change another. I have a button.
Okay, sure. Okay, sure.
What is
Yes, much better.
much better.
Ah, yeah. Yeah, thank you.
What I was saying just now that I'm sorry for the inconvenience for the first speaker, but it's okay. I'll be lenient because you are the first speaker. Get the benefit of that. Okay, please proceed.
Am I audible to the court? Testing. Am I audible to the court?
Yes.
Good afternoon. May it please this court. My name is Siti Nurafika Azizi, appearing as the co-counsel on behalf of the appellant. I will now address the court on the second issue. I propose to take 18 minutes of the honorable court for my submission. My lord, may I begin my submissions proper?
Before that, anything you want to add on the facts of the case?
I think my senior counsel had explained well. There's no much from me.
Okay. Please proceed.
Much of it. My lord, for the second issue, we submit that the trial judge erred in failing to determine the vicarious liability of the second respondent in protecting the appellant from harm or risk of injury. My lord, in order to show that the second respondent is vicariously liable for the first respondent's act, I will be addressing 3 grounds in fulfilling the requirements of vicarious liability in my submission. The first one, there must be special relationship between the defendant and the tortfeasor. Second, there must be wrongful act committed by the tortfeasor. Third, the tort must be committed within the course of employment. The first ground, there was an existence of special relationship between second respondent and the first respondent. Yes, my lord.
Before that, do you have any authority to support these 3 elements? Because you are stating the elements of law here.
Thank you for pointing that out, my lord. In assisting this court's concern, we would like to refer to the case of Tan Eng Siu and another, and Dr. Jajik Singh Sidhu and another, where Justice James Fung has outlined 3 requirements in this case in order to prove the issue on whether the second defendant is vicariously liable towards the first respondent.
Which case is that? Tan Eng Siu, is it?
Yes, my lord.
Okay.
Much obliged. The first ground, there was an existence of special relationship between second respondent and the first respondent. In the case Vincent Manikam, son of David and others, and Dr. S. Hari Raja and another, the Court of Appeal held that the second respondent was liable for the first respondent's act, as there is contractual agreement between them and the fact that they share some common interests. In the same decided case, which is the Vincent Manikam case, the medical consultant was also pictured as a professional medical practitioner. The second respondent owned the hospital pursuant to the meaning in Section 2 of Private Healthcare Facilities Act 1998 as a healthcare facility where the public receive healthcare services. This provision states diagnosis of a person believed to be suffering from any disease are also included as healthcare services.
Okay, this issue arises. Sorry, counsel.
Yes, my lord.
The issue arises because there is a different term used, which is a medical consultant instead of medical practitioner. So you use this, you raise this issue, right?
Indeed, my lord.
Anything on your comments about the term regular doctor? Will that be considered as a doctor patient as well? Because you see, among the elements of vicarious liability, you must prove the relationship. Is it?
Indeed, my lord. Yes.
Okay, how about the regular doctor? I'm referring to the fact here right now because it's not a legal jargon or what, but it could be amount to different legal consequence if it's a legal regular doctor.
My apology, my lord. Could you rephrase your question?
Okay, just now you are raising on the issues. You're saying that there's no dispute whether it is a medical practitioner or medical consultant. My question is that because when we look at the fact, we can see some of the in which could related to the relevant law, and I see it as the term regular doctor. Of course, it is not a legal jargon or what, but I believe uh, I'm not. I believe, but I asking you, Counsel. Do you think that there's there is different legal consequences due to that term, regular doctor, because it also carries the fact that appellant didn't come to SMX and then he met the respondent, but it seems like appellant already know the respondent earlier. Do you get my question? My concern?
Yes. Thank you for pointing that out, my lord.
Okay.
Um, my lord, if I may receive this court's question correctly, is your lordship asking if whether the appellant in this case is dependent towards both doctor and also the hospital?
I'm just asking on the relationship between the appellant and also the first respondent.
Much obliged. In addressing this court's concern, um, yes, my lord. Indeed, the first respondent is an independent doctor at Nilai SMX Medical Center. However, we submit that there is a special relationship between Dr. Kevin and also Nilai SMX Medical Center in regards to the practicality of his medical skills under the hospital. This is because he is working under SMX Nilai Medical Center, even though the title stated that he is an independent doctor.
Yeah, I'm done yet with my question, but I can see where you are heading to. Can you just proceed first?
Much obliged. My lord, pertaining to this issue, in the case of Tan and Siu and another and Dr. Jajik Singh Sidhu and another, the High Court held that the hospital was not vicariously liable towards the doctor as they did not own full control in the form of treatment, management, and care upon the plaintiff. Therefore, my lord, may I refer my lord's attention to the answers for clarification.
Okay.
Question number 4.
Hold on. Question number 4. Okay.
Uh, in paragraph 2 from the mood problem, yes, this could be distinguished in the present case as although Dr. Kevin is an independent doctor, the fact that he works under SMX Nilai Medical Center has obviously shown that the management of the patient's data, such as the registration and the records, are under their keeping.
So you are saying there's no issues on the relationship between the doctor and the hospital, the clinic here, right?
Yes, indeed, my lord.
Okay.
In reference to the case of Chai Beng Ho and Sabah Medical Center, Sendirian Berhad and others, the High Court held that the hospital was vicariously liable towards the medical consultant through special relationship as the doctor was obviously for all intents at all material times representing the hospital when giving treatment to the plaintiff. This showed that the hospital had control over the doctor's practice at the hospital. Therefore, my lord, in the present case, upon referring to the clarification answer which I had mentioned before, Dr. Kevin works under SMX9 Medical Center, which shows that the engagement between them, thus proving that Dr. Kevin is a servant or agent of SMX Nilai Medical Center. My lord, in my submission, I will be addressing the interpretation of the word non-delegable duty. Non-delegable.
Before that,
Yes, my lord.
can I go back to your issue just now? So you are saying that Dr. Kevin, he represent SMX clinic. And based on the case that you cited, you are showing that it is important to have a relationship between the doctor and also the clinic here, employer, employees. I have a simple question. Who is appellant actually? Appellant, is she the patient for Dr. Kevin, or is she the patient for SMX clinic?
Thank you for addressing this matter, my lord. In addressing this court's concern, we submit that the appellate, Mrs. Amrita, is dependent towards both Dr. Kevin and also Nila SMX Medical Center, which is the second respondent in this case.
Yeah, I can see it. You try to link the first appellant, the appellant and to the second respondent here. But the way we look at the fact, I can see that the second respondent or clinics, whichever the clinic Dr. Kevin employed to, is immaterial because he's her regular doctor. It seems like she's convenienced with him, and let's say he's a medical consultant working in KPJ, for example. It seems like whoever the clinic here is not necessary. How could you link it to the second? Because your issue is vicarious liability right now, right?
Yes, indeed.
The way I see it is you're attempting on linking or absolve the liability as well to the clinic.
Indeed, my lord. We understand your concern.
Okay.
However, if I may refer to the case of Vincent Manikam, son of David, and others, and Dr. S. Hari Raja and another,
Okay.
where in this case, the second respondent remains always in control of the first respondent, that it provided not just the place, materials, or medication staff and tools for the first respondent to render his management, treatment, and care of the appellant. It was mandatory for the first respondent to treat, manage, and care for the appellant at the second respondent's hospital.
I stop you there for a while. Okay.
Yes, ma'am.
In your first issues that was presented by your learned counsel, you are saying that the duty of care was breached by the doctor, and now you are trying to link the liability to the clinics. The way you put your submission right now is as you are trying to say that the sins of the clinic here is he employed the first appellant. Is it? Because that's the way it is. Because you're trying to say why a second respondent is vicariously liable because they are just the employer for the first respondent. Because can you present any fact saying that there's any precaution or that was undone by the second respondent?
My lord, if I may receive this court's question correctly,
Okay.
is your lordship asking whether, although in this mood problem, it has not been stated that there were no contractual agreement between them, then how can the SMX Medical Center is vicariously liable? Is it?
Yeah, but I didn't say that there is in a mood problem, or I didn't say whether it is in mood problem or not, because you will answer that. Is it in the mood problem or not? Because yeah, and I took your submission from the beginning. I mean, the first issue, which you are saying that it is the breach by the doctor. You are referring to the fact that it was Dr. Kevin who failed to make a referral to the appellant. How could you now relate it to is it there is a practice or procedure of the clinic? Will there be any precaution that the clinic should ensure? Should they remind the doctor? Did you mention that? And even if it is not in the mooting problem, could you make a general assumption on this is a general knowledge, involving on the how the practice in the clinic, in the private clinic should be.
Thank you for pointing that out, my lord. In addressing this court's question, it is normal where we could say that when a doctor is being under the practice of doesn't matter which private it is, it doesn't matter whether he is working and where he is working for, and like in this case it is at the hospital, but it is a natural where we could say that a doctor should have a full duty of care towards all his patients. Yeah.
Okay, that's quite general. Please proceed.
May I continue with my submission or?
Yes, please.
All right.
We will go
Much
through that
obliged.
later. Just proceed first.
Right. Therefore, my lord, in the present case, upon referring to the my lord, in my submission, I will be addressing the interpretation of the word non-delegable duty. Non-delegable duty refers to the prohibition by the employer to get rid of his responsibility by delegating it to the employee, despite of whether the employee is under a contract of service or an independent contractor. This proposition is supported by the case of Dr. Kok Chung Seng and another, and Su Cheng Lin and another, where in this case, the federal court adopted the principle in the case of Management Corporation Strata Title Plan and Tiong Ait Construction Pte Limited and another, where the Court of Appeal propounded that where an employer is liable for any act committed by an independent employee upon any non-delegable duties. Also, in the case of Vincent Malcolm, son of David and others, and Dr. S. Hariraja and another, the Court of Appeal held that the private hospital was vicariously liable for the negligence of the first respondent, whereas non-delegable duty of care existed.
Can you
The
explain
moment,
what is non-delegable duty, delegable and non-delegable duty? Can you explain on that, please?
indeed,
Okay.
much obliged. Non-delegable duty, if we could say in simple words, it refers to the when it is a prohibition by the employer to get rid of his responsibility by delegating that kind of responsibility to the employee, despite of whether the employee is under a contract of service or an independent contractor.
Okay.
The moment the patient was admitted to the doctor, she became a patient of the private hospital, vulnerable and dependent on the hospital to protect her from risk or injury or harm. My lord, may I refer my lord's attention to the mood problem?
Yes, please.
Page 1, paragraph 2,
Okay.
line 6. Which states that Dr. Kevin is an independent medical consultant at SMX Nilai Medical Center, which is a private hospital. In the present case, my lord, this means that special relationship is established between them. Thus, SMX Nilai Medical Center should not get rid of its responsibility by delegating it to the employee.
I think, okay, I'll get back to my first question just now, because I think here it should be, because you disregard. Can I have more time for this counsel? Is it okay? Because I, as usual.
Yes.
Okay. It seems like you disregard the fact that she's a regular doctor, because here you are saying to say that this relationship, doctor-patient relationship. I make it simple to you that this relationship could be in any fraternity, for example, solicitor's client, for example. There is a difference, right? When you walk into a legal firm, and then you as client ask the solicitor to represent you. Same goes to a patient. There is a difference. If a patient come to the clinic and he expect any doctor to come and entertain him, to treat him. Now in this case, I'm saying that there is a prior knowledge between the patient and Dr. Kevin. It seems like there are something else rather than doctor-patient relationship. Nothing too much, but there is a prior knowledge, which means there is another trust involved, whatever it is. But that might jeopardize the duty, which is currently there is another. If in a more serious matter, we call it there's a conflict of interest. Maybe not here, but there's that kind of possibility here, because he's the patient of Dr. Kevin. She's the patient of Dr. Kevin in SMX, but at the same time, Dr. Kevin is her regular doctor, which they met him frequently, which the fact left silence on what is it. But there is a prior knowledge that's very important. And I think you disregard that fact. You refer the court to the fact that on the dispute of there's a medical consultant, it's still included in this matter. But it seems like you disregard that fact.
Thank you for pointing this matter out, my lord. In assisting this court's concern, indeed, as appointed by my senior counsel earlier, certainly we submit that Dr. Kevin had failed to make this referral regarding Mrs. Amrita's diagnosis, where at the same time, Dr. Kevin had appointed Mrs. Amrita towards other treatments as well.
You're saying that basically there is a breach of duty made by Dr. Kevin. Right.
Indeed, my lord.
But at the first place right now, you haven't made it clear on whether there is a duty, there is a relationship between the parties. Do you get me? Because of course, there is a relationship, but you didn't make it clear whether they both come in clean hand here. Because I believe in in any mood problems, there are hints. Everything is connected in some of the regular terms that might connected to any legal consequences that will be the relevant issues in your submissions, basically.
My apology, my lord. I'm not that clear about what my lord is addressing on. Can you rephrase the question?
Have time? Have more time? Mrs. Delif, I
Yes.
still got time?
Um,
How many time left?
Timekeeper.
Sorry?
Sorry, I have to ask a timekeeper how many life,
Alright.
how many times left.
Now it's running more.
I give you 5 minutes more.
5 minutes. Okay,
Okay.
I think maybe 5 minutes. Yeah, can address to the court on the issue. Your comments. You are saying that the issues of the facts on Dr. Kevin is Mrs. Amrita's regular doctor is immaterial here. You can make it easy now, actually. If you say that, I mean, I don't have to ask further. Is it immaterial?
Indeed, as been stated in the mood problem, Dr. Kevin is Mrs. Amrita's regular doctor.
So is it immaterial or it doesn't matter whether it's a regular doctor or just doctor?
It is material that he is a doctor towards Mrs. Amrita, who owns a duty of care towards his patient.
The words regular doctor carry no meanings, no any legal consequences because of there's a term of regular there. You're saying so?
No, we understand your concern, my lord. However, regular doctor means that he is still a doctor who owns a duty of care towards his patient, which in this case is Mrs. Amrita.
Okay. It seems like you are firm with your stand there. Okay. Do you have any other issues? You may proceed.
Therefore, I would like to proceed on to the second ground, which we submit that the first respondent had committed tortious act, which is negligence as he had breached his duty towards the appellant. We refer to the case of Dr. Gan Suk Chin and Kata Kau Anak Perempuan Jari Singh and another, where vicarious liability is imposed to the employer not because they have breached their duty towards the plaintiff, but because of the employee had breached the duty owned by him towards the plaintiff. This is supported in the case of Chen, Tamkong, and Accident Strategies Sendirian Berhad and others, where the High Court held that a doctor owes a duty of care towards his patients based on skills of ordinary competent doctor in their respective medical fields, such as duty to diagnose, advise, and treat his patient.
So you see,
Moreover,
can I stop you for a while? So you see,
yes, ma'am.
according to your case, you were saying that before you want to apply the vicarious liability, of course, at the first place, you have to ensure that there is a duty of care has been breached. Is it?
Indeed, my lord.
Okay.
Moreover,
Do you have any other
re-
issues rather than this?
yes, my lord.
Okay, can you skip to other issues, because I think you made it clear for this. Uh, if there is other issue
Uh,
or other addition,
we would like to proceed to the last round of my submission.
yes, please.
The last round that which we would submit that the negligence of the first respondent towards the appellant was committed within the course of his employment. We refer to the case of Century Insurance Co. Limited and Northern Ireland Road Transport Berhad, where the driver negligently threw the burning smoke on the floor, which caused explosion at the plaintiff's petrol station. The House of Lords held that the defendant to be vicariously liable towards the driver as he is negligent within the course of his employment.
Okay, you are saying that because the negligence happened in the course of employment, then the employer is liable as well.
Indeed.
Okay. Once again, I repeat my question. You are saying that basically, what is the sins of the SMX clinic is because they employ this first respondent. Is it because you are established the link between the parties? As simple as that. As if because okay, do you have time? I think on your the issue on law is clear already. You have made your submission on the case. Just can you explain briefly what should the hospital do to ensure this thing does not happen? Is there anything that the hospital or the clinic can do? Or the only solution is not to employ this doctor? Don't tell me that.
My apology, Mala. Is it you asking if
Yes.
what is
What can the clinic do to ensure that this is not happen? I can see from your submission you are saying that they shouldn't employ this doctor, as simple as that. Because is that what you are saying? Because no one knows about the doctor. No one foresee this doctor can handle the case. What can the clinic? What is your suggestion to the clinic basically? Mhm.
in addressing this court's concern, what we would suggest for the clinic is to ensure that that
Okay.
to ensure that the the doctor is exercising his duty of care which he owns towards the appellant, which is the patient.
You mean the clinic have to remind the doctor? Can we have more extension of time here?
Yes. I could give 5 minutes more or 7 minutes.
5 minutes first we try. If not, then we'll need another extension. Where were we just now? Okay, I'm asking about what can the clinic. Yeah, what do you expect from the clinic basically? Because I see that you are going too technical to the law right now. You're setting authorities. How do you apply this to the clinic? What should they done? Or your cases doesn't mention anything on that? Currently, we are saying that if we want to make anyone liable, they must be liable for any of their action or omission here. And I see it's unfair to say that the clinic is vicariously liable because he just employed this doctor. Because I believe it's a general knowledge. Everyone knows that as a clinic, they will do the due diligence whether this is a doctor, a real doctor or not. I think they have passed that one. Should they investigate further on the ethics of this doctor? Or are you serious that that's your suggestion? Now we are saying that the doctor is already in the clinic. Is there any policies that you can suggest that when the fact is still there, you can see that there's an omission from the clinics?
Thank you for addressing this matter out, my lord. In addressing this court's concern, we would like to say, how can the second respondent, which is the doctor, the hospital, can what the hospital should do is in matters of to monitor the employees, which in this case is the doctors, to monitor whether the act conducted is under
Clinic
their
have to monitor the doctor, you're saying? The clinic have to monitor the doctor.
yes, my lord.
You read your cases that you cited just now. You have
Yes.
the of the case. Can you refer any of the cases which saying so, which the doctor need to be monitored by the clinic? Because I believe that's where your submission should goes on the applicable application of the case law. Can you refer the court? But you're submitting the hospital or the clinic should monitor, right? I take it from yeah, for a while I can take it. Do you have any other submission on the law for that?
Back to my
If
submission.
not, okay, I mean, if no, it's okay.
Maybe if you could say that to the fact where there exists a special relationship between the doctor and the hospital in this case.
But you're saying the existing relationship is just uh, relationship between the doctor and hospital. The way I see it is that you should prepare your submission more on the what is your suggestion, not your suggestion, but there you can see how you apply the law from the case, because what happened is that you are keep submitting that in this case there is a breach of duty, in this case there is a contractual relationship, in this case there is a duty of care, as simple as that. You should go deeper to the fact to apply in this case. But yeah, I have your submission in the end. You're saying that the hospital should monitor the doctor. Do you have any other ground, or you want to conclude the submission?
No, this is my last ground.
It,
May I conclude my submission?
yes, please.
Therefore, in concluding the second issue, the appellant submits that the second respondent must be held liable under vicarious liability as the elements of vicarious liability had been fulfilled. In conclusion of the appellant's submission as a whole, it is submitted that firstly, the learned trial judge erred in finding that there was no breach of requisite standard demonstrated in Dr. Kevin's action in the delay of the referral and in failing to find sufficient causation between the failure to advise of the risk of the bladder cancer and the brain damage suffered by the appellant, and hence the respondent is liable under negligence. Second, the learned trial judge erred in failing to determine the vicarious liability of SMX Nilai Medical Center in protecting the appellant from harm or risk of injury. If the court requires no further assistance, this concludes the appellant's submission, and I pray that the court will find in favor of the appellant and will allow the appeal accordingly. Much obliged, and may it please the Honorable Court.
Thank you, Concern. Okay, Believe, are we going to proceed or what? We are proceed, right?
Yes, proceed with.
Can the counsel for respondent are they ready, or I think it's okay if they might need a break. What do you think? Or just want to proceed?
I'm with my lord, as you please.
Sorry, you're ready?
Yes, if you want us to proceed.
Okay, I'll leave it to Believe and the timekeeper.
Okay, you may begin now.
Am my mic clear?
Can you speak clearly? Slowly and yeah, I think it's clear. You can proceed.
May I begin, my lord?
Yes, please.
Much obliged. Good afternoon, my lord, and the members of the court. My name is Muhammad Mustafa bin Abdullah, as the senior counsel, and I appear on behalf of the respondent with my learned co-counsel, Mr. Muhammad Arif bin Masiran. It is an honor for me to appear before this honorable court. I'll be submitting on the first issue for 18 minutes, while my learned co-counsel will be submitting on the second issue for another 17 minutes, and we will reserve 5 minutes for rebuttal. My lords, my ladies, going through into this proceeding today, the respondent, who is an independent medical consultant at SMX Medical Center, a private hospital that giving his
You're going to
diagnosis.
the fact of the case, right?
Yes. Do you want me to skip?
Not to skip, but can you just give your opinion on the facts that was summarized by the Council of Appellant just now? As simple as that.
Yes, my lord. Much obliged. My lord, it will be in my intention to bring to the court of the meaning of independent medical consultant by referring to the paragraph 199, page 467 of the case of M. Gurusha Taranjit and another against Dr. Primita Damadoran.
You have the case?
Which states,
right
yes, my lord.
Can you refer me to the case?
Yes. Paragraph 199, page 47 of the case of M. Gurusha Taranjit and another against Primita Damadoran.
Believe, is it possible if they can make a screen share? Yeah, because in court we do it that way nowadays. Is it possible? And if counsel, can you screen share the case you are referring to?
Yes, of course, my lord.
Believe?
Moment.
Okay. Because that's in our current practice right now. That's how we do it.
Can you see my screen, my lord?
Yes. Okay.
I was referring to the paragraph 199, page 467 of the case of M. Gurusha Taranjit and another against Dr. Primita Damadoran, which in this case stated that all medical consultants or healthcare professionals who have practicing rights at the hospital are independent medical practitioners and are not employer of the hospital, which means that he is not a worker in the hospital, as has been claimed by the appellant, my lord. Proceeding to the first.
Okay.
Can I stop share?
Okay, that's the only thing that you want to add on your fact, right?
Yes, my lord. Much obliged.
Okay, can you proceed with your submission?
Yes, my lord. I'm proceeding to the first issue. We argue that there was no sufficient causation between the respondent's negligence and the appellant's damage.
Can you say it again? The first issue, sorry. Can you say it again the first issues slowly?
Yes, my lord. With regards to the first issue, which is there was no sufficient causation between the respondent's negligence and the appellant's damage. That is our first issue.
Sufficient causation?
Yes, my lord.
Okay.
To deal with the insufficiency causation between respondent's negligence and the appellant's damage, I will divide my submission into two subgrounds.
Okay.
Into two grounds. Pardon me, my lord. First, I will argue that the trial judge was correct in finding there was no sufficient causation between the respondent's negligence and the appellant's damage, which may be divided into two subgrounds, which are the respondent act still in the good conduct as a professional doctor, and the respondent already fulfills his duty as a doctor. Second, I will argue that the delay made by the appellant in seeking the treatment has amounted to contributory negligence, which also may be divided into two subgrounds, which are the appellant has neglected her duty to take care and put further concern on her disease.
You're saying the respondent has neglected their duty of care.
The appellant, my lord.
The appellant, you're saying.
Yes, my lord.
Okay, you put it to the appellant. Okay, okay.
Yeah.
Please proceed.
Which is into two subgrounds. The first one, appellant has neglected her duty to take care and put further concern on her disease, and the appellant also, her injury is reasonably foreseeable from her own act. My lord, before I proceed, is there any preliminary question?
Please proceed.
Much obliged, my lord. With regards to the first issue, we submit that the trial judge was correct in finding there was no sufficient causation between the respondent's negligence and the appellant's damage, since the findings made by the trial judge are found to be solid and concrete based on the facts of
Can you
the
slow
case.
down first a little bit?
Yes, my lord.
Tempo.
I'm sorry, my lord.
Yes.
With regards to the first issue,
Okay.
we submit that the trial judge was correct in finding there was no sufficient causation between the respondent's negligence and the appellant's damage, since the findings made by the trial judge are found to be solid and concrete based on the facts of the case and by rules and principles of the law, such as the Boehm's test. For the first subground, under the Boehm's case, it laid out that the Boehm's test works as an indicator to check whether a man had breached his duty of care or not. Based on this rule, the respondent had performed his act in good faith and professional towards the appellant as any other medical practitioner would do. While, pursuant to Boehm's case also, a doctor is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that medical act. In other words, a doctor is considered as performing his own act in good faith and professional if it will be aligned with any other act of doctors in the same situation. Expert evidence provided by Professor Dr. Azran, a pathologist from Seremban Specialist Center, was uncontradicted. He told the court that
What? Sorry. Uncontradicted. You're saying?
Yes, Ms. Malaj was uncontradicted.
Okay. Yes. Please proceed.
I shall blush, my lord. He told the court that with no adverse prognostic features, such as those occasioned by the delay in referral, she would have had remission chance of approximately 40% and a similar chance of survival for 10 years. The delay meant her initial chance of remission would have declined to around 25%. This particular delay of referral was actually referring towards the delay of referral made by the appellant to XYZ Hospital, as what has been urged by Dr. Hans to do so urgent. If I may direct the court to the third page in paragraph 4.
I didn't see where you're going. Are you against your own case right now, or you are not done yet? Because
I am on the.
you're refreshing the medical expert opinion just now, right?
Yes, my lord.
Okay. Are you agree with it or what?
Yes, I agree that the delay of referral was actually the delay of referral made by the appellant herself.
You agree? Come again? You agree?
If you refer to the delay of the referral, the statement made by Professor Dr. Azran,
okay,
he stated in a general statement which does not refer to any special site. So I am explaining that the actual referral that the Dr. Azran is mentioning was referred to the act of the appellant herself. My lord.
Understand. You are playing it the other way. You are saying that there is a delay, but the delay was not due to the respondent, but the appellant.
Yes, my lord.
Okay.
Indeed. Thank you, my lord.
Explain further on that. I'm intrigued.
I'm sorry, my lord.
Can you explain further on how was the delay was due to the appellant in this case?
Yes, my lord. If I may direct the court to the page in paragraph 4, the state urgency that has been advised by Dr. Hans occurred during February to March 2019. Yet, if we refer to the paragraph 5, stated that the appellant had only executed the referral to the XYZ hospital only on July 2019, and she was admitted on 25th August 2019.
Okay.
It is clear that, yes, my lord.
Please proceed first. I have
Yeah,
my question, but please proceed first.
It is the act of the appellant to delay the referral made by Dr. Hans to seek further treatment from Exeter Hospital. Clearly, this shows that the respondent, as in the rule of Willem's case, was not breach of duty and performed his duty in good faith, which is he had gave the diagnosis and he could not be held liable or breach of duty to the delay of referral. May I proceed, my lord?
So you are trying to say that it was the appellant's duty to foresee what might happen after have been advised on there is SPMS. Are you
Yes,
saying
my lord. Indeed.
okay? The way you put it is that you are trying to absolve you as the appellant try to absolve that the matter was settled the moment the doctor said it's SPMS, as simple as that. That's what you're saying?
Yes, my lord. It is his duty was already finished when he already gave the diagnosis
Okay.
towards the appellant. If I may cite the case of Dr. TZTA against Dr. Joshua Mohanraj Daniel and another, which was decided by the High Court in 2018, it was held that the doctor would not be considered as breaching of his duty of care if he had fulfilled his duty. Therefore, he is considered as conducting his act in good faith and professional. In this case, my client.
Okay, can you assist the court on the duty to treat and the duty to diagnose? Can you bring any case law to show that it is sufficient for the doctor to simply mention what the disease it is, then leave it to the patient to the rest, like DIY or what? Can you show any case law on that? Because I believe
Yes,
that this is a legal element. It involves on the duty in medical law, duty of the practitioner.
Yes, my lord.
Okay.
If I may bring to the court of the case of Zulhasnima, Zulhasnima binti Hassan Basri and another against Dr. Kupur Velumani, the judge stated that the duty to diagnose and treat needs to be distinct from duty to advise. In this case, the appellant had claimed that the first and second respondent was breach of duty to diagnose and treat when they failed to diagnose the first appellant of being in the state of labor and to treat her sooner by giving her the cesarean section, and failed the duty of advice, which is to warn the appellant of risks of the procedure.
Is this case applicable to our situation, counsel?
Yes, my lord.
I mean,
applicable. Yes, my lord.
Are you distinguishing it or you are applying it? Because the way you explain it, that's how I see it. In our case, they managed to say that there is a SPMS and the doctor here failed to refer her to the specialist.
My lord, if you refer to this case, the judge stated the judge in this case stated that the first and second respondent was not liable of breach of duty to diagnose and treat, as they had performed these duties, and they are not liable for breaching duty of advice.
Can you come again?
The court ruled that the first and second respondent was not liable of breach of duty to diagnose and treat, as they had performed these duties, and they are not liable for breaching duty of advice, as the court distinct these duties between one and another.
Can you explain further why did he is not considered as breach his duty in this case? Can you explain
Because
further on the back of the case and how to distinguish this or apply this and how this case is similar to our case?
In this case, the court ruled that once the doctor has gave the diagnosis towards the patient, then he is considered as fulfilling his duty to diagnose. And the other duty, such as duty to treat and duty to give advice or warn of the risk, should be considered as another duty. And a doctor should not be held liable if he could only did only one of these duties.
You're saying that he's discharged his duty already by diagnosing the patient. Then he was discharged from another duty. Okay.
Yes, my lord.
Commission?
Yes, my lord. I will proceed for my submission. If we refer to our current case, my client was claimed for breaching his duty and was claimed to be responsible for the damages that the appellant had. The appellant seeks for medical treatment due to the numbness she had prior to 9 months before deciding to seek treatment, and she went to the respondent on October 2019. While the respondent had given the diagnosis towards the appellant did not attend to get the treatment that she's supposed to get from the respondent for 5 months. Later on, starting on February to March 2019, only then the appellant had treatment from Dr. Hans and XYZ Hospital, and only after receiving the chemotherapy treatment from Dr. Hans and XYZ Hospital and on 25th August 2019, by the date of October 2019, the measures started to emerge and consuming the appellant's health. It must be noted that the appellant was already informed on the basis of side effects of the treatment and the procedures that she would undergo under the course of the Hans and XYZ Hospital, which is the bladder cancer and the brain damage. It is clear that only after 15 months by the diagnosis made by Dr. Kevin,
Can you slow down, please?
Yes, my lord. It is clear that only after 15 months of the diagnosis made by Dr. Kevin, only then the appellant decided to pursue or to take another treatment, which she sought from Dr. Hans and XYZ Hospital, and the damages was due to the treatment made by Dr. Hans and XYZ Hospital. This clearly showed that Dr. Kevin did not commit professional negligence and had conducted his duty as a medical practitioner in good faith, and there was clearly no sufficient causation between his action with the damages that Amrita suffered. If I may direct the court to the third page of paragraph 11 of the moot problem,
Okay.
the appellant appealed to the High Court as she questioned whether the trial judge was correct in finding there was no sufficient causation between the respondent's negligence and the appellant's damage.
Counsel,
Therefore,
I believe that you're going technical here, and the way you put your submission is you are saying that the doctor in this case he absolved or resolved already his duty from referring the patient to the specialist, and can you please enlighten the court on is that really the duty of doctor? Because I think, yeah, the law that you explained make it sense, but logically it doesn't make sense that way.
could you paraphrase your sentence, my lord?
Sorry?
Could you paraphrase your sentence, my lord?
Okay, the way I see your submission is that you are trying to say that the doctor have no duty. The doctor could foresee that this SPMS could lead to bladder cancer. Now, you're saying that he's not liable. You're saying that his duty resolved the moment he said SPMS. As simple as that.
Yes, my lord.
You're saying that?
Yes, my lord.
Okay. Because the way you explain it, is that actually it was he's the reason all the damages was, if you explain about the causation, he is the reason there's a damage concur between the parties here, because he failed to give the duty. Basically, what happened is that you are pleading the matter. You are pleading it right now. You are pleading.
My lord.
Yeah, that's
much obliged, my lord. What I'm trying to say here is that my client should not be held liable for the damages that the appellant had. But the first reason is that between the diagnosis given by my client towards the appellant and the treatment.
We have more extension of time here?
Yes, Mr. Chairman.
Okay, 5 minutes.
Okay, 5 minutes.
5 minutes first. Okay.
Between there has been a gap of 15 months, my lord, between the diagnosis given by
months was due to the fact that Dr. Kevin does not advise him to refer to any specialist. I'm saying here as a patient, everyone could be a patient here. The moment you see the doctor, the moment you met the doctor, then there's no next appointment. There's no advice on what to do next. What do you think? I think it's resolved there. I think, yeah, I'm fine. I'm healthy. Are you saying that? Because
Yes, my lord.
every normal person will feel the same way. I'm using my logical explanation here, because when you meet the doctor, then there's no next appointment. The doctor simply said that SPMS, no any suggestion to make any consultation with the specialist.
Yes, my lord. Much obliged.
Mhm.
My lord, the doctor of a patient
Okay.
have the right to determine whether how to conduct the treatment. If I may direct the call to the Code of Professional Conduct 2019, under the Power of Medical Act 1979, amended 2019.
What is this? What is this?
Section
Is it the authority? Yeah.
Yes, my lord.
Which is it? The act you are referring to?
Code of Professional Conduct
Code of
2019.
Professional Conduct.
There's not in the submission. Sorry, it won't have in the my memorial.
Should include it. But please proceed first.
Sorry, my lord. Sorry, my lord. If you refer to this code on the page 11, stated that a registered medical practitioner will provide and maintain a good standard of medical care. And there's a explanation of what a good standard of medical care. If you refer to the item B, which said that sufficiently thorough professional attention, examination, and where necessary, given diagnostic investigation, which is this act as a law to be applied that my client has already fulfilled his duty to diagnose. And if you refer to the item E in the same code, which stated that readiness where the circumstances are so warrant to consult or refer the patient to appropriate professional colleagues, means that the doctor himself has the power to determine whether it is should be made another appointment or should be referred to another specialist.
So you are saying that the doctor have the right to refer the patient to a specialist, and in this case, Dr. Kevin choose not to. You are saying that because that's how you put it right now.
No, my lord. What I'm trying to say
you're
is
saying
that
that there's a right, but are you saying that's the right thing for him to do according to that code of professional conduct? Because you're giving him privilege right now, statutory privilege for sure, because you are referring to the provision. Does that mean he have the liberty to choose not to refer to the specialist? The way you put it right now is that yeah, he have the right, and he have the right to determine whether this issue is serious or not. He maintained it that this is SPMS. He as a doctor know that how serious it is, and he choose not to refer to the specialist. And now you're saying there's the right on behalf of him.
yes, my lord. If we could refer to the mood problem,
Okay.
it does not state it clearly whether my client had made the referral or he did not want to make the referral. But in this particular case, in this current situation,
Come again.
the client has
now the mood facts now.
the mood fact. It does not state it in the mood fact
Okay.
whether my client did make a referral or did not make, and it does not state it, meaning that we don't know for sure, right, my lord?
Are you saying that after the of course we don't know, but in any normal clinic, private clinic, are you saying that there's no follow up, there's no medical card, not medical card, appointment card given, because this involve on the general knowledge? You see, since court have the authorities to determine all areas of practice, you see the court have the authorities to determine the matter involving on the construction, which involve on the construction knowledge, on the building knowledge, on the architecture. The court also have the duty to determine on the issue on accident matter, which involve the ability on forensic knowledge. Now you see, the moment you inform that he have the right to do so, I believe that there is an explanation, because I didn't see the explanation on how did he say that he resolved his right as simple as that. I mean, he resolved his responsibility as simple as that because of the right prescriber.
My lord,
Huh.
if I may please to explain
Can
the
we have more
court.
time, please, for this
Yes,
council?
There's
Please.
5 minutes more.
Okay, sure.
yes, my lord. In logical situation, of course, a doctor would make an observation first, and after making some observation, only then he would decide whether to make some advice, or whether to give some treatment, or whether to give some other referral towards another specialist. But in this case, my client could not do any of that because of the absentee of the appellant, that she did not attend to the clinic for 5 months after the diagnosis is given. Therefore, my client could not be held liable.
So isn't that the duty of the doctor? Because Ms. Amrita is not the doctor here.
Yes, my lord.
That's what I'm
But
saying.
yeah.
Yeah, that's what I'm saying, that
Yes, my lord. My client could not do any of that because of the absentee of the appellant to the clinic. If the absentee would come to further appointment,
I see
or
that
do so,
you plead the fact that I see that you plead the fact that the clients or the appellant couldn't reach the clinic. But I think the issue that you should resolve here is that on whether who should have that duty. Is it clients or doctor? Because I believe the duty of we have medical law, and the duties goes to the doctor. And I don't
yes, my
think I
lord.
satisfy with your submission that simply saying that the duty to the duty to diagnose is separated with other duty. You are saying that the duty of the doctor rests there the moment he said that this is SPMS. You leave it to the client to figure out later. Do you have any case law to say that I'm intrigued on the case law that you can refer if it is related to the duty of the doctor?
Yes, my lord.
Because that's your main point here, your main submission.
Yes, my lord. The duty of my client has already resolved when he had give his diagnosis, and he could not do any other kind of duty. And the case law that I am referring to is the case law of the Zul Hasnima binti Hassan Basri,
Okay.
which in this case, the judge stated that between one another duties, which is duty to treat, duty to diagnose, and duty to giving warn or risk or advice, are need to be distinct between one another. And if a doctor has fulfilled a duty, one of that duties, then he should be not held liable for the breach of the duty. And the breach of the duty that we are referring here right now is that the appellant claim my client are negligent when he failed to make a further referral.
That's the hell from the court. You have the fact of the case. Why the court say so? Because when you want to apply it, you have to apply the fact to fact, not the judgment to the facts. You get me?
Yes, my lord.
Mm.
In the case of Zul Hasnima, the first respondent was had already given her diagnosis towards the patient, which is the appellant, and another doctor had proceed and continue on giving the treatment.
There's another doctor.
Yes, my lord. We have first and second respondent in the case of Zul Hasnima. The first was held not liable for breach of duty of giving diagnosis and advice.
Okay, in that case, is there anything mentioned on the first doctor that he asked to refer to the next doctor? Is it mentioned in that case?
No, my lord. he just stated that in that case, the
I believe in our issue right now, the issue that we are disputing that the duty of the doctor to warn the clients on the risk of the SPMS right now. So I believe in your submission, you should include that.
yes, my lord.
Mhm.
My client did not execute the duty to treat or the duty to advise of the risk because he could not do so, my lord. And that duty has been executed by Dr. Hans and the XYZ hospital.
You try to make it sense, but legally it's not basically. You're trying to make it sense because there's your logical explanation that Ms. Amrita couldn't reach the hospital. Mhm. Okay, since time's up, can you conclude? You have other issue?
I have a second round if you
Sorry?
want me to proceed.
Have your second round. Your second round is
Actually, the second round, we already entered into the second round once you asked me about the previous question.
I see.
Which
Anything for you to add?
no, my lord. I shall conclude my submission.
Okay. Please.
As a conclusion, the respondent cannot be deemed as abandoning or breaching his duty to inform or warn or duty to diagnose. In other words, the respondent is not liable for breaching his duties because he could only perform the duty to diagnose, which later was confirmed by Dr. Hans, and he could not perform the other duty, which is the duty to treat and the duty to inform or warn due to the appellate absentee for 5 months. And later, she get her own treatment and the advice of the risk from Dr. Hans and the XYZ hospital. In conclusion, there was no sufficient causation between the respondent's negligence and the appellant's damage due to the respondent's act still in the good conduct as a professional doctor, and the respondent already fulfills his duty as a doctor. As such, the respondent submit that the judge was correct in finding there was no sufficient causation between the respondent's negligence and the appellant's damage. My learned co-counsel will continue to submit on the remaining issues. Much obliged, and may it please the honorable court.
Before that, Belif, how much time do we have basically?
20 minutes per person means 40 minutes for. Right?
We're going to stop at 4, right? We should stop at
3.
Is it possible?
Yes.
Yes. Okay. So should we just proceed with the last counsel? But please try to make it clear but precise and refer to relevant issues. Please proceed.
May I proceed, my lord?
Yes, please.
Much obliged.
Proceed to your issues, please. Can you proceed with your issues?
All right. For the second issue, we submit that the delay made by the appellant in seeking the treatment has amounted to contributing negligence. My lord, there are 2 grounds to be submitted for the second issue.
Okay.
The first one is the appellant has neglected her duty of care to take care and put further concern on her disease to seek medical treatment.
Come again, please. Come again, please.
The appellant has neglected to her duty of care to take care and put further concern on her disease.
You're repeating the first issues as well, right? From your first counsel. Okay.
That is my first ground.
Okay.
Okay. My second ground is the appellant injury is reasonably foreseeable from her tardiness and the delay.
It's reasonably
Foreseeable.
Foreseeable. Okay.
Yes. For the first ground, we submit that the injury suffered by the
Do you have
appellant.
any issues on vicarious liability? You are referring to the ground of judgment, is it? Straight away to the ground of judgment, not the ground of appeal.
For vicarious liability, regarding the vicarious liability issue by second counsel, I realize there is no problem with close relation has been established, and Also, the act of tort was committed.
So you're saying the issue is immaterial here, right?
Yes.
Okay, please just proceed with your submission first.
Much obliged, my lord. Uh, for the first ground, we submit that the injury suffered by the appellant due to her own negligence by delaying seeking the treatment. Hence, she is committing contributing negligence. My lord, before I go further, I come up with this issue in my case. In case my client is involved with any negligence. My lord, according to section 12, clause 1 of Civil Law Act 1956 stipulate that where any person suffers damage as the result partly of his own fault and partly of the fault of any person, a claim in respect of that damage shall not be defeated by reason of the fault of the person suffering the damage. In the case of Shafi'i bin Zainal Abidin and others, and Shah Alam, officer in charge of Police District or CPD and others, I choose this case to assist the court to interpret the term act reasonably. Therefore, we could determine whether the appellant has act reasonably or not in order to avoid the injury. So the main issue arose whether the defendants act reasonably with the reasonable cause
Explain
in
the fact of the case, please.
uh,
Briefly on the fact of the case.
Briefly on the fact of the case of Shafi'i bin Zainal Abidin and others, and Shah Alam, officer in charge of Police District or CPD and others.
Okay.
The main issue, the defendant act reasonably with reasonable cause in discharging firearm that caused death of disease. In this case, the defendant had no way of escape. When the first, second, and third disease attacked them with parang, and they had to take out their guns as a last resort in self-defense.
I'm intrigued how you will apply this case to our situation.
All right, much obliged, my lord, for the question. As I said before, I choose this case to assist the court to interpret the term act reasonably, my lord.
Okay, you decide to choose you choose this case just to explain to act reasonably in very remote situation. Right now, you're in fact you're submitting your case which involves the self-defense. That is a defense involved provided in penal code, while we are discussing a civil matter right now. Okay, but can you please proceed first?
All right, my lord. Thank you. Much obliged. In answering the issue of the case that I submit before, the court held that defendants were consistent in their evidence of each other and they had reasonable cause to open fire in self-defense. Therefore, the 5th to 11th defendant were not liable for assault and battery, public misfeasance, and also negligence. My lord, it could be relating both authorities, which the law and the case shows that the appellant failed to act reasonably to avoid the injury. Hence, the law should prevail where the amount should be contributed to his own negligence. But in the case of Hamizan bin Abdul Hamid and Wong Kok Kiong,
Yeah, can you apply first how this case is relevant to our case? In our situation, in our present situation, with appellant and the first respondent, how do you say that there is a reasonable act by the respondent?
Much obliged, Lord. So to referring back to the case, current case, we can see that Amrita's tardiness in seeking treatment with Dr. Kevin is not a reasonably act, my lord.
You're saying Amrita's act is not reasonable.
Yes, my lord.
Honestly, I see that it's a misinterpretation of the fact of the case there on how you relate the case of sorry, come again, the case just now?
The case of Shafi'i bin Zainal Abidin.
Yeah.
And others. Shah Alam, officer in charge of Police District or CPD and others.
Because I see that your case are saying about the reasonable act to open fire, is it?
Yes.
to open fire and it involved of the self-defense. I really can't see what is the connection with this question in this case. Do you want to enlighten me or not?
I will enlighten you in the further case.
Yes, please.
Much obliged, my lord. My lord, as in the case of Hamizan bin Abdul Hamid and Wong Kok Kiong and others,
Okay.
where the contributing negligence was being used and clarified in the case as the disregard to the plaintiff own safety by unreasonable behavior of him which caused a foreseeable damage to himself. My lord, therefore, the plaintiff not having a duty of care to the defendant, but the duty of care is open himself to act reasonably as to avoid the damage to himself. Due to the current issue, if I may direct the court to page 1, paragraph 3 of the moot problem, the appellant was not trying to act reasonably, which is to attend and meet up with the first respondent, which is Dr. Kevin, after 5 months consulting with him. Therefore, the appellant had breached duty of care toward herself to act reasonably.
You're saying Mrs. Amrita didn't act reasonably by not catching up with Dr. Kevin in 5 months. So you're saying there's a reasonable, it is reasonable for her to meet Dr. Kevin. You're saying so. So you're saying it is reasonable to do so, but in your case, did Dr. Kevin give any notice, any next appointment on that?
Much obliged, my lord. As the layman, if we feel sick, we will find a doctor.
Okay.
Okay. So in this case, Amrita's tardiness and also carelessness to meet up and meet up with Dr. Kevin.
Isn't she already met Dr. Kevin and she already explained to Dr. Kevin about the illness and the way you explain it? Yeah. As a layman, of course, she met the doctor and she expects something else as a follow-up. I see it. It's basically you are saying that the act of Amrita to meet Dr. Kevin is not reasonable. By saying so, you are saying that Mrs. Amrita should see Dr. Kevin, is it?
Yes, my lord.
And now, I believe the question, the issue that will decide, the kingmaker in this issue will be the issue on who should give the notice, who have the duty. Is it the duty of the doctor to ask him to come, ask her to come, or Amrita, she herself, sorry.
Amrita herself, because if she feels sick, because of the numbness or something, or else,
okay,
she herself has to act reasonably by going to the doctor.
I think she already done her part. What's the point? The meeting in October 2017.
Much obliged, my lord.
You are saying that there must be another symptom, another different symptom. Is there any other different symptom? Because she's relying on her current symptom. And then she met Dr. Kevin. I'm trying to make it sense right now.
Much obliged, my lord. The symptom of multiple sclerosis is a general symptom like numbness and others. But if you can see, my client, which is Dr. Kevin, has expertise to detect that it is a multiple sclerosis, right? As stated on the mood problem. So in this current issue, after the 5 months, after Amrita seeking the treatment, she must, if she feel healthy, she should not make any appointment with Dr. Kevin. But if she feel sick, so she must attend and make appointment with Dr. Kevin.
So you said she must make the appointment with Dr. Kevin.
Yes.
Dr. Kevin explained that, yeah, I'm going to the fact right now. Does Dr. Kevin inform that because according to the fact, Dr. Kevin just said it's SPMS. Is there any fact mentioned that Dr. Kevin did give notice to Mrs. Amrita? If there's anything you feel like something else come, or at least anything to follow up on that matter? Yes or no?
No, my lord.
I
But
think
if
to
we,
make it simple, right?
yes, my lord. But if we can see in the mode problem, paragraph 2, line number 4, the appellant made an appointment with the first respondent, Dr. Kevin,
Mhm. Yeah.
which can reflect with the another appointment, which is to make an appointment first before meeting with Dr. Kevin.
Sorry, come again, come again. That part. You're referring on the appointment on October 2017. Only one appointment, is it?
Yes.
There's only one appointment. I take it here. I still take it as that. I still take it from you that Mrs. Amrita, it is reasonable for her to have another appointment, but the doctor has failed to make any appointment, to make any follow up. I'm not saying to make to refer to any specialist right now. I'm not saying his duty to refer to specialists, but just still a duty to diagnose, duty to treat, to ensure if it is really SPMS. Yeah, I believe you make a research on SPMS. It's a chronic disease. Does it adequate by this kind of disease when the first time we discover, then it ends there. There's no follow up. Is it reasonable by that way? I don't think it's reasonable. Yeah, I'm referring to your case right now. On what is reasonable. I don't think it's reasonable if we're applying that case. You want to assist me on this, or you want to disregard it?
I will assist you in this issue.
Uh-huh.
Also, as you stated, as the court stated that it is reasonable for Dr. Kevin to make an appointment, right? So, if the appellant, which is Mr. Amrita, has known about the SPMS, right? So, if she know about it, she has a obligation to meet up with Dr. Kevin regularly, as stated by the by her that she is a regular doctor.
Who decide that? Because who have a better knowledge on the SPMS right now? The doctor, right? Shouldn't the doctor is the one who decides that there's another appointment on that? Because prior to the knowledge that Mrs. Amrita have, she only have the knowledge that she suffer from SPMS. Now you're saying that it is reasonable for her to have another appointment to meet doctors. I believe that's medically it is so, right? It is reasonable medically as well. And who know medic better than the medical practitioner here? I think it is when you say reasonable act. I'm still stuck in your first case on the reasonable act. I think it is doctor here who didn't act reasonably.
I will correct the first case, which is Shafiq Zainal. So the term act reasonably is when
So because is there any self-defense? Is there any such a thing as threat as parang from this case?
yes, because it's the police officer act, which is to open fire the disease,
Okay.
is a reasonable act.
Okay. I couldn't honestly I couldn't agree with you on that because that's two different things, two different situations, and in fact it's too remote to apply that. You can find a other better case in terms of acting reasonably, specifically under the medical law cases, basically. And this is too remote. I really can accept with this submission on this case. Okay, maybe we can just disregard it. Can you proceed with other cases or ground, please?
Much obliged, my lord. So I will continue with my second ground, which is the appellant injury is reasonably foreseeable from her act.
the appellant
appellant injury is reasonably foreseeable from her act, which is the tardiness to seeking the treatment.
Okay, so what is your stand on this issue? You're saying it is foreseeable, is it?
Yes, my lord.
You're saying this. You're saying that it's foreseeable that the appellant might suffer from bladder cancer. Now, who knows better about that? Is it first respondent or the appellant?
Absolutely, the first respondent.
The first respondent, who is a layman here? Sorry, the first respondent is a doctor, right? Okay,
Okay.
sorry, I'm sorry. You're saying the doctor, right? So you're saying the doctor have a better knowledge about that.
Yes.
But you're saying the appellant is the one who should see the doctor, is it? Is the one who have the knowledge to make the appointment with the doctor?
Much obliged, my lord. So I will referring to the two tests, which is but-for test and also the causation in law. So in the but-for test,
3 minutes.
Can actually we afraid we couldn't allow the additional time because as we need to proceed with the rebuttals and rebuttals.
Just
2 minutes
2
to
minutes.
conclude.
Yes. Okay.
so but-for the defense. So I will continue my conclusion, my lord.
Yes, please. Yes, please. Anything you think necessary? Conclusion or your second ground?
My second ground a little bit, and then I will conclude.
Okay, please. 2 minutes.
So the two tests to determine. First is the but-for test and also the causation in law. So I will go through the case. So in the case of Peramelu anak lelaki Berapan and Dr. Amijit Kaur and others, the plaintiff eyes was removed because of foreign body or object, and she claimed toward the defendant. So Viti Singham, the judge, in his judgment stated that there was a lack of evidence showing the positive link.
1 minute left, right?
Positive link between the plaintiff's injury and the act of the first and second defendant. There were no objective fact that the loss of plaintiff right eye had shown some negligence on the part of the defendants. So, my lords, the next issue, the next case is Tenaga Nasional and Batu Kemas Industry. When the
Conclusion.
okay, I will conclude. That's my lord. We submit that reflecting to the present issue, damage suffered by the appellant Abita were possible, and she could have prevented if she come to the responder regularly. Therefore, the appellant injury is reasonably
So submission, you're saying it is foreseeable, is it?
It is foreseeable. Foreseeable.
Possible to Amrita, you're saying?
Yes.
Okay, but it's foreseeable. Okay.
Foreseeable, reasonably foreseeable. So therefore, the appellant injury is reasonably foreseeable according to her acts, which is delaying the treatment. Is there any clarification needed by the bench before I conclude the overall submission?
No. Thank you very much, Counsel.
Much obliged, my lord.
Okay. I leave it to you.
Okay, now we will proceed with the rebuttals and rebuttals.
Yes.
May it please the court, the appellant will now rebut to 3 points. The first point, the respondent submitted that the Boolem test should be the applicable test. However, which I have cited this case earlier, which in a recent High Court case of Chai Beng Ho and Sabah Medical Center, Sendirian Berhad and others, where in this case, the High Court had conceded the Boolem test, but nevertheless decided to remain with the Roger and Whittaker test. The same test, which is the Rogers test, is also being applied to the 2009 case of Chien Tam Kong and Excellent Strategies Sendirian Berhad and others. This clearly shows that the Malaysian court has deemed it unnecessary to adopt the Boolem test. But in this case, the High Court pointed out that the court's reliance on Boolem test appears to be outdated, as the federal court in Fu Fiona had clearly discarded the test propounded in that case. The court is in the view that the Rogers and Whittaker test would be more appropriate and a viable test of this millennium than the Boolem test. Further and more importantly, particularly in the field of non-disclosure of risk and the provision of
Sorry,
advice
can
and
I stop you for a moment? Can you suggest what test is more preferable?
the Rogers and Whittaker test, my lord.
Just and we take okay. Okay.
Uh, the, the Bolen principle has been discarded, and instead, the courts have adopted the principle that while evidence of acceptable medical practice is a useful guide for the courts, it is for the courts to adjudicate on what is the appropriate standard of care after giving weight to the paramount consideration that a person is entitled to make his own decision about his life. Therefore, the appellant respectfully submits that instead of the Bolen test, this court should apply the Rogers test as the applicable test. The second point, in my learned opposing counsel submission, where it has been submitted that the appellant has breached the duty of care towards herself in acting reasonably to avoid the damage suffered by the appellant. However, my lord, as appointed by my learned opposing counsel, where the appellant has breached the duty towards herself is irrelevant in this case, as we will respectfully submit that, in reference to the answers for clarification question number 12, as clarified based on paragraph 2, line 7 and 8 of the moot problem, where she consulted Dr. Kevin and followed his advice accordingly. Although based on the moot problem, which stated that the appellant attended infrequently, this do not show that the appellant has delayed in consulting with the first respondent, thus had breached the duty of care towards herself, because we submit that based on the answers for clarifications, where the appellant did consult and follow his advice accordingly. Therefore, my lord, this shows that the first respondent did not make further follow-ups towards the appellant in this case, and if so, specifically if the first respondent had prepared the appellant to certain treatments or consultations, the appellant would attend and adhere to any treatments and consultations promptly. As such, the appellant hereby submits that the appellant has not breached the duty of care towards herself in acting reasonably to avoid the damage suffered by her, also to the fact where there exists a doctor-patient relationship based on the case of Fu Fiona and Dr. Su Fu Moon and another. Therefore, there was breach of the requisite standard demonstrated in the first respondent's action in delay of the referral. Hence, the respondent is liable under negligence. The third point, the appellant would like to rebut on the argument of contributory negligence as submitted by our learned opposing counsel. Since there exists a contributory negligence, therefore it clearly shows that the respondent agree that there is also negligence committed by the respondent's act, which in this case is Dr. Kevin. Hence, the respondent should be liable for negligence due to the breach of duty towards the appellant in failing to diagnose, advise, and treat his patient pursuant to the case of Chen Tam Kong and Excellent Strategies, Sdn Bhd and others. Hence, in light of our submission, we pray that the court will adjust and declare in finding in favor of the appellant. And if the court require no further assistance, this will conclude the appellant's rebuttals. Much obliged, my lord.
Please proceed for the counsel of respondent.
Much obliged, my lord. The respondent has 3 points to be made in this rebuttal session. Firstly, the appellant claims that the respondent is in breach of requisite standard as there is a delay of referral on the appellant. My lord, Dr. Kevin does not breach of requisite standard based on delay of referral because in his opinion as a medical doctor, she does not need to be referred yet, and indeed she needs to be treated as soon as possible. Yet, it is the absentee of the appellant for 5 months after the diagnosis is given, and due to that, the respondent could not put her under his further observation or even to give any kind of treatment or even to give any referral to a specialist. The respondent had exercised his duty of professionally when he gave her the diagnosis, and that is the only thing that he could give to her due to the appellant circumstances of being absent for 5 months after the diagnosis is given. Secondly, even though if he could foresee the damages that the appellant would have, the respondent should not be taken into account for reliable on the damages that emerge due to the treatments made by Dr. Hans and XYZ Hospital. My lord, if I can please the court to refer to second page, paragraph 6 of the moot problem, clearly stated that the damages...
Which moot problem you are referring?
Second page on the paragraph 6.
Paragraph 8, okay.
Yeah. Clearly stated that the damages such as tumor in the regional lymph nodes, gastrointestinal obstruction and bleeding problem, causing her to feel weak and lacking in energy ever since the relapse, was caused by the original treatment. particularly to the high-dose treatment in August 2019. The original treatment here absolutely referring to the treatment she received from Dr. Hans and XYZ Hospital, because if we refer to the first page, paragraph 3, clearly stated that the appellant did not receive any kind of treatment from the respondent due to her absentee for 5 months after the diagnosis is given. Lastly, the appellant claimed that the respondent is a worker on SMX Medical Center, but in reality, he is not a worker at the hospital. I'd like to bring to the court to refer to the definition of independent medical consultant by referring to paragraph 199, page 467 of the case M. Gurusha Taranjit and another against Dr. Primita Damadoran, which the High Court stated that all medical consultants or healthcare professionals who have practicing rights at the hospital are independent medical practitioners and are not employees of the hospital. Therefore, the respondent would pray to the court that there was no sufficient causation between the respondent's negligence and the appellant's damage, and the trial judge was correct in finding and the delay made by the appellant in seeking the treatment has amounted to contributory negligence. Therefore, that should conclude my submission to the court. Thank you, my lord. Much obliged.
Thank you very much, counsels. I think you all deserve a clap for yourself. I didn't hear anything. Yeah. Okay, Belif, we are going back. At what time?
Yes.
4:15.
For 4:15.
4:15. Sure. Okay.
Because after break for Solat.
Okay.
Okay. And then after that for the feedback session. Sorry.
4:20. Is it possible for 20?
Okay, for 20.
4:20. So the matter.
Yes. But Mr. Shamil, you have to fill up the score sheet first.
Okay. Are you waiting for me or what? Can I fill it now? Before.
Yes.
Fill it now. Okay.
But the participants need to leave the meeting first.
Okay, sure.
Back to the breakout room.
Okay. Okay.
The main room.